A good question. At the same time, guys, it's this would actually it could be its own seminar. Should be, because there are so many different aspects of due process. So due process, what to expect? I submitted and I received the document from the court. Help. All right. So what to expect? I'm going to give you an overview, but at the same time, like I said, this is really something that I should do in a, a future seminar, like webinar type of thing, because like I said, there's a lot of nooks and crannies and procedure, but at the same time, I know it seems daunting. Okay, it did for me when we first started. At the same time, once you get over it, I mean, any unknown is going to be the same way. Now let's start here. Under IDEA, even under 504, the parents have within it the right to advocate and act as their own attorney. There's only a few areas within um, the law in this country where private citizens can act as their own attorney. Most of the time, you need an attorney in order to have access to the court. Um, well, it just sort of depends on what the situation is. At the same time, I don't recommend in many of these instances ever doing anything without an attorney. It's the reason we exist, okay? But in this particular area, when it comes to the advocacy for your child, there is a carve out. In fact, it's more envisioned for parents to act as their own attorneys. Quite frankly, I'm sort of the outlier. It was originally intended that the parents would work through this process with regards to dispute resolution without the need of an attorney to be involved. Now, at the same time, because of how our society has evolved and the fact that the school boards get to use their attorneys, I think it would be a different situation entirely if if the school was not allowed to use their board attorney during hearings, if the parent did not have an attorney. At that point, I believe that it would be more of a level playing field, quite frankly. And I have I've I've rubbed shoulders with enough special education directors to know that some of them should never have been put in those positions in the first place, and that, in my viewpoint, should be the person to have to carry the. I'm talking about the special education director should be the one to have to carry the heavy water for the district with regards to the argument, being that they would be the head of the special education department for the district. That would be in the James Galini perfect world of how I think equity should exist when it comes to parents acting pro se, which is saying that the parents representing themselves or representing their child, and they don't have a trained attorney like myself to make those arguments for them. Okay, and so I think that on an equity standpoint, the school system should not be allowed to use their board attorney, and I'm talking about on any capacity uh, when it comes to this administrative level of arguing. And but then again, how do you sit there and prevent the board attorney from working behind the scenes? That happens now, guys. Many of you that are in the throngs of disputes with the even minor ones, you would be shocked at how many times I've contacted the board attorney and they already have a file on you. They already know who you are. Why would they know that? Why would it matter? What danger do you pose to the institution that the school felt that they needed to spend money because board attorneys charge money to have the board attorney create a file on you? This is prior to you asking for mediation, prior to you complaining formally in any formal capacity. But they sort of, and it's not uncommon, with the parents that ask too many questions, they start files on them. All right. So that's where, when a lot of my cases, the board attorney, this is not the first time they've heard your name. Okay. Now, to what your situation is, I mean, I don't know where you live, and I don't know what you filed due process about. I can just sort of speak broadly to what the process is. You file your complaint, they will assign a hearing officer or administrative law judge, depending on the state you live in. And at that point, that's when the timeline starts. Within the first 15 days, and that's calendar days, it's not business days. Within the first 15 days after you filed and after you've been assigned a hearing officer, those 15 days start ticking along. The school system must convene what's known as a resolution meeting. Must happen within that 15-day time period. Now, that resolution period or that resolution meeting is intended for the school system, okay? Not necessarily intended for you. Your complaint is basically your explanation of the issues. The resolution meeting is intended as a first opportunity for the school system to sit down with you to discuss the dispute and see whether or not you guys can reach an agreement. But and the state, with regards to state monitoring, keeps very close track of the school systems and their adherence to that resolution timeline, that 15 days. They can choose to waive it and not participate in it at all. And you could sit there and say, well, I want my opportunity for resolution meeting. It's a one-sided requirement. I don't ever recommend that a parent refuse to participate in a resolution meeting, because at that point, now it has become a problem because you've denied the school system their opportunity to participate in a resolution meeting. All right. It doesn't work the other way. If the school doesn't want to have a resolution meeting, doesn't look very good on them, but they don't have to, they don't have to if they don't want to. It just doesn't look good. But at the same time, if they waive it, you can't force them to have a resolution meeting. It just means that you move on to your next step. It just means that you get to bypass that 15 days and you get to move to the next step of hearing. Okay? Which is what you requested. You requested a due process hearing. And so that's something that parents really need to understand, is that the resolution meeting within the first 15 days is a one-sided requirement that the school system must convene one. They can waive it, but if they do convene one, I'd never, ever, 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 ever recommend that the parent not participate. It looks bad on the parent. And there's just no need. Now, if you want to waive participation jointly to where both of you are like, I really don't think that we're going to make much progress at resolution, but let's jointly agree to waive resolution and go to mediation, because mediation is a different format. And even if you have a resolution meeting within that first 15 days, you still could request the next opportunity to try to resolve it through a mediator, through a mediation. Now, the state departments of education all throughout the country will provide a trained mediator to the parties free of charge. I think that's beneficial, depending on who the mediator is. So if you get a mediator that, let's say, was a retired educator, a retired director, sort of understands these laws, I find it beneficial. But if you don't have a mediator that is trained specifically in the fine nuances then I don't find it beneficial. Why? Because the problem isn't necessarily, the problem's both sides. If the parent's acting without an attorney, because you're talking about a lot of unknowns, and so therefore parents are highly susceptible to being fed false information, being manipulated. That's why I think it's important to have a special education attorney there, not just a regular attorney. Because when you're starting to get into the negotiations for resolution and settlement, then there's a high likelihood, if you do not understand all aspects and requirements and what you could be entitled to with regards to parental reimbursement, compensatory services, remedial tutoring services, um, you know, evaluation requirements, those kind of things, then at that point there is that susceptibility for a school system to take advantage of a parent um, and manipulate these outcomes to get rid of the due process complaint to where, I mean, it was a minor irritation on the district instead of a bigger irritation on the district, which means that the parent wasn't able to accomplish fully what they would have been able to accomplish if they would have had somebody with them that had the requisite knowledge. That's why, if you can't, depending on the state, if an attorney just isn't available, that's where what we really need to do is really focus on um, training and preparing an army of advocates, parent advocates that are willing to go to these meetings, like mediations and IEP meetings with parents, at a low cost in order to help bolster and help advise and help guide. Okay. As far as special education attorneys, I don't recommend they be used, let's say, at IEP meetings. Mediation, yes. Um, I think it would be absolutely beneficial because at that point, oh, and guys, on the resolution meeting, I'm backing up. If you happen to have a resolution agreement, okay, and you're able to fashion an agreement, you have 3 business days, not 3 days. There's a big difference in the law with regards to what business days are and what calendar days are. Okay, so if you do have a settlement agreement or a resolution agreement that you're able to come to within that first 15 days, then guys, you have 3 business days to um, think about it and change your mind if you so please before it gets finalized. If you end up going to mediation, you end up coming to an agreement in mediation, then it's an immediate. It's done. There is you can't change your mind. It also is a process to where there's a lot of confidentiality involved with regards to not being able to have a free and open discussion of negotiation without the risk of having those offers or those things said in mediation used against each other. Let's say if mediation doesn't work out and you end up having to go to hearing, you can't introduce the prior offers or the things discussed on the day of mediation. You can't do that. But I do think mediation is a positive process. After that, if what I'm saying is the whole time the timeline's going, mediation will sort of naturally extend that out because you need to schedule and have that opportunity to mediate. At that point, you need to work with the hearing officer to get a hearing date scheduled. And then per the rules, I mean, depending on the state, I mean, you may need to produce some other documents to the hearing officer, pleadings, things of that nature. And the hearing officer is supposed to be there as a neutral, but they're also supposed to be there sort of as a guide for you to sort of explain and simplify what it is that you're required to do. Okay? And then at that point, whatever evidence that you plan to present, 5 days, 5 days prior to the hearing, you're required to exchange those documents. Okay, and you're supposed to provide your list of witnesses and the list of exhibits that you plan to present. So anything that you plan to put forward must be exchanged with the school. Anything that they plan to put forward. During this time, if you file a due process, then you have a right to request immediately on the outset, on the of your filing, access to the full education record. Okay, and they need to produce that because you're acting on. In fact, within the IDEA, you're entitled to have a copy of your child's full education record prior to even that resolution meeting. And many schools will not do that because they don't expect parents to sort of understand what those rules are. But the rule's in there. You just need to sit there and make sure that you make that request and you make it, immediately that, per the regulations that you need your child's education record in advance of the resolution meeting in order for you to fully prepare and provide the best opportunity to resolve the issues. Okay. So anything that they provided to you with regards to the education records, you don't have to, let's say you look through your child's education record and you see a bunch of stuff that you want to present. Well, you need to put that in your exhibit list, but you don't necessarily have to turn around and hand back to the school what they handed you, because most of your exhibits should come from your child's education record. Well, where's your education record coming from? Well, it's coming from the school. The only thing that you need to exchange is anything that they don't have, okay, that you will be relying on, and make sure that you hand it over prior to that 5 days, okay, because if you don't, then there's a high likelihood that you won't be able to present it at all. And then as far as hearing is concerned, I mean, you would be able to give an opening statement, beforehand, and then you would put on what's called your case in chief first. And typically to save time, they will utilize the cross-examination by the board attorney, and that sort of changes the structure of how they're able to question witnesses. Is that they usually, for saving time, especially if the board attorney is going to be calling the same witness as you, then basically you get 2 shots of direct examination and then cross-examination. That's why some of these things take a lot of time. A lot of the due process cases that we've been in have been 5, 6, 10, 12 days long. Okay. They're very complex. And the reason that it's actually, quite frankly, it's harder to argue a special education due process case, because in most states you don't have the opportunity to depose people in advance. We just don't do that. So the first time that you are questioning somebody is the day of the hearing, and you have no idea what their answers are going to be. And you got to be real savvy and know what you're doing to question somebody where you don't know the answer that's going to come out of their mouth. And then at that time, you also have to be very, very good and quick on your feet to understand how to question depending on what that answer is. All right. I mean, there's a lot of trial lawyers in this country, guys, but and now that's not to sit there and toot my own horn with regards to how the complexity of what it means to be a special education attorney and argue these things. But I'm telling you that because we don't have the opportunity to question people before these hearings, these things get complex, they get fast, and you got to think quick on your feet. You got to know where to pivot. You got to know, so as a parent, you've got to stay focused on what you're there to prove. Okay. And I mean, I'm going to wait for you to make some additional comments on what it is that you're arguing, what are the issues? And if you present that, then at that point, I think it would be good to have a follow-up video so that I can explain how you would need to frame your due process arguments in a hearing, okay? And then I can tell you that the board attorney is going to be throwing out red herrings and diversions to sit there and take the attention off of those issues, okay? It's a tactic. I mean, it's done. But that's where I'm saying, a parent can do it, but they just sort of need to understand the tricks of lawyers and what they need to do to stay singularly focused on the issues that need to be proven. Okay?